The first letter arrived on a rainy Tuesday morning. It landed on Daniel Hartman's desk among court briefs, unpaid invoices, and coffee-stained notes from cases that never seemed to end. Daniel was a defense lawyer, 10 years into his career, respected enough to stay busy but unknown enough to stay invisible. He learned early that the justice system rewarded silence more than questions. The envelope was thin. Prison mail. Daniel almost set it aside. He didn't. The letter was from a man named Marcus Bell, serving a life sentence for a murder committed 12 years earlier. Marcus wrote carefully, as if every word mattered. I was convicted on evidence that never existed. Please help me prove it. Daniel had read hundreds of letters like this. Desperation had a familiar handwriting. Still, something about the wording caught his attention. Not emotional, not angry, precise. Daniel leaned back in his chair and sighed. He told himself he'd just skim it. 2 hours later, he was still reading. Marcus claimed the prosecution used a fingerprint report that was later corrected, but never disclosed to the defense. He claimed witnesses changed their statements after private meetings with detectives. He claimed the same prosecutor had handled at least 6 similar cases. Daniel closed the letter slowly. One false conviction was tragic. A pattern was something else. He pulled court records that afternoon. The fingerprint report existed. So did the correction. The original defense attorney never received it. Daniel's stomach tightened. He requested the trial transcripts, then the evidence logs, then internal memos through public records requests. Each document revealed something small, almost invisible on its own. A date that didn't line up, a signature missing, a lab test performed weeks after it was supposedly logged. Nothing screamed corruption. Everything whispered it. Daniel visited Marcus in prison 2 weeks later. Marcus was calm. Too calm. I knew no one would believe me, Marcus said. But you looked. Daniel nodded. I did. What did you find? Enough to worry me, Daniel said. Not enough to win. Yet. Marcus smiled faintly. That's how it starts. Daniel filed a motion to reopen the case. It was denied in under a minute. The judge cited procedural limits and lack of new evidence. Daniel expected it. Still, the denial felt heavier than it should have. That night, Daniel couldn't sleep. He kept thinking about the prosecutor's name, Richard Cole. Cole had built his career on tough convictions, high clearance rate, media-friendly sound bites. Promotions followed him like shadows. Daniel searched Cole's past cases. The deeper he looked, the more familiar the details became. Missing evidence, last-minute witness changes, jailhouse informants with generous plea deals, defense attorneys who complained quietly, then moved on. Daniel created a spreadsheet. 1 case became 3. 3 became 12. 12 became 32. The pattern was undeniable. But patterns don't overturn convictions. Proof does. Daniel began contacting families. Most didn't respond. Some yelled at him. A few cried. One mother said, "You're 10 years too late." Then one former juror called him back. "I always felt something was wrong," she said. The timeline didn't make sense. Daniel asked if she'd testify. She hesitated. Against the system? I don't know. I do, Daniel said, and it's ugly. He filed another motion, this time for prosecutorial misconduct. It was denied. Again, Daniel's colleagues warned him to stop. "You're burning your career," one said. "Even if you're right, you won't win," said another. "They'll bury you," said a third. Daniel didn't argue. He kept working. Late nights turned into early mornings. His private practice suffered. Clients left. Bills piled up. Friends stopped calling. Then the anonymous email arrived. "I worked evidence intake for the DA's office. What you're looking for is real." Daniel's hands shook as he read. The sender described internal pressure to clean up weak cases. Evidence logs altered. Lab results delayed until witnesses aligned. Attached was a single file, a spreadsheet. It listed case numbers, dates, and instructions. Daniel stared at the screen. This wasn't just one prosecutor. It was a system. He contacted the sender through encrypted channels. "I can testify," the whistleblower wrote. but only if I'm protected. Daniel reached out to an investigative journalist he barely knew. She read everything. Then she went quiet. 2 weeks later, her article dropped. The headline didn't mention Daniel. It mentioned numbers. A decade of convictions under review after evidence irregularities uncovered. The reaction was immediate. Public defenders demanded audits. Civil rights groups mobilized. Families protested outside courthouses, holding photos of loved ones forgotten by time. The DA's office denied everything. Richard Cole called it a smear campaign. Daniel filed motions for post-conviction relief in 7 cases simultaneously. One judge granted an evidentiary hearing. Just one. It was enough. Under oath, the whistleblower testified. Then a forensic analyst admitted results were expedited selectively. Then a retired detective said, "We were told not to ask questions." The courtroom went silent. The judge ordered a full review. Within months, convictions began to collapse. Marcus Bell was the first released. He walked out of prison holding nothing but a manila envelope and 12 years of stolen time. More followed. 5, 10, 17. Then the number reached 43. The state launched an independent investigation. Richard Cole resigned before charges were filed. The report confirmed what Daniel had uncovered. For over a decade, convictions were secured through manipulated evidence, coerced testimony, and suppressed reports. Lives had been destroyed to protect statistics. Daniel was called a hero by the media. He didn't feel like one. At a press conference, someone asked him why he didn't stop sooner. Daniel paused. "Because the system is designed to discourage people from looking too closely," he said. "And it works." Compensation checks were issued. They weren't enough. Some men couldn't sleep in quiet rooms. Some didn't recognize their children. Some didn't trust freedom. Marcus visited Daniel months later. "They took 12 years. Marcus said, "But you gave me the rest." Daniel shook his head. "You gave it back to yourself. I just listened." The investigation ended. The headlines faded. But courtrooms across the state changed. Evidence procedures were rewritten. Prosecutorial discretion was monitored. Conviction review units were created. Not everywhere. Not enough. Daniel kept practicing law. He no longer waited for letters. He searched for them, because one lawyer exposing a decade of false convictions didn't fix the system. It only proved how badly it needed to be questioned. Subscribe to this channel to watch similar justice stories. Like and share the video if you believe in justice. Drop your thought on Daniel's story in the comment. We will definitely read them.